Hi, everyone. I'm Nicole Hemrick. I'm the managing partner at Hemrick O'Malley, PLLC. And I am joined today by my fabulous partner, Allison Grosz. Hi, Allison.
Hi, Nicole, and hi, everyone. My name's Allison Grosz. As I was introduced, I'm a partner and an attorney with Hemrick O'Malley.
So today, we are talking about parole in place as we keep getting more and more information about this. Allison, can you tell us when USCIS is going to start accepting parole in place applications?
Yeah, they just announced that they're going to start accepting the applications on August 19th, so we're very excited.
What happens if people send them in before August 19th?
Well, if you send it in before August 19th, then it will be rejected.
And interestingly, while we can guess what form this is going to be, we don't know exactly yet, right?
That's true. Yeah. I mean, traditionally, the parole in place for military family members has been submitted on a form I-131. It is my hope that it is not going to be that on this form because that is a very messy process for military parole in place family members, but we shall see.
Here's hoping. So can you remind us who's eligible for this new parole in place program?
So what we do know is that this is going to be eligible for family members, certain family members of United States citizens who are present in the United States without having been admitted or paroled into the United States. We also know that this is going to be specifically for spouses, children, and stepchildren of United States citizens. It's available for people who have been physically present in the United States for 10 consecutive years. That means 10 years without break or departing the physical presence of the United States as of June 17th, 2024. That means that you have to have 10 solid years from June 17th, 2014 until June 17th, 2024 in order to be eligible for this. In addition to that, another qualifying criteria is that you have to have been married to a U.S. citizen if you are a qualifying spouse as of June 17th, 2024. That means that you couldn't have rushed off and gotten married on June 18th or June 19th after they announced this process in order to qualify for it. Unfortunately, you have to have been lawfully and validly married in the jurisdiction where you live or in any jurisdiction within the United States or outside of the United States by June 17th, 2024. A couple more qualifying criteria is that you, of course, cannot be disqualified by certain what they call qualifying criminal convictions, which we will talk about probably in another couple questions or so. You also have to not pose a threat or any sort of problem towards the U.S. national security or the safety of the public in the United States. And lastly, you have to be eligible or otherwise just qualified based on positive discretion, meaning you have to show and prove to the U.S. government that you are a person of good moral character.
Do we know anything about what these disqualifying crimes might be?
No, we don't know anything about what these disqualifying crimes may be. However, we can anticipate that they are going to be similar to other disqualifying crimes in an immigration context. And some of those disqualifying crimes are most commonly referred to as crimes involving moral turpitude, which are, this is a non-exhaustive list, but crimes that involve theft, fraud, driving while under the influence of substances, and other kinds of just sort of bad moral crimes. It also includes disqualifying crimes such as drug trafficking, crimes such as aggravated felonies, which is a legal term of art that, of course, an qualified attorney can go over with you whether you have been convicted of an aggravated felony. And in addition to that, you, of course, cannot have been charged with or convicted of any crimes that involve or touch on espionage or terrorism inside of the United States. Those are generally the all-encompassing crimes that would disqualify you from most immigration benefits in the United States.
Great. Thank you for that. And I guess more to come once this gets published in the Federal Register. So you mentioned a little bit about children and stepchildren. Can you tell us who are children and stepchildren?
Well, we know that children and stepchildren are also going to be qualifying relatives under this new parole in place program, but we don't have the exact specific qualifying requirements for those children and stepchildren as we do for the marriage-based qualifying relatives for this program. But what we do know is As always, children of U.S. citizens or stepchildren of U.S. citizens, meaning they were born to the U.S. citizen and the spouse who is going to be obtaining the benefit of this, or they are the stepchildren, meaning they are the children of the spouse who is going to be obtaining this benefit, and therefore the stepchild of the U.S. citizen. And in immigration contexts, it's pretty much always unmarried under the age of 21.
Who qualifies as a stepchild?
Well, stepchild is the child, of course, of the spouse of a U.S. citizen in this context, and the marriage between the U.S. citizen and the parent of the stepchild has to have taken place before the age of 18.
What can spouses of U.S. citizens do right now to prepare?
We don't have an exhaustive or even any sort of semblance of a list of documents that can be collected, but we do know, and USCIS has given a little bit of guidance on some documents that can be collected. For instance, we know that you have to prove 10 years of continuous physical presence inside of the United States up until June 17th, 2024. That means that you can start collecting documents to show that you've been physically present in the United States, such as things like medical records and reports, lease agreements, bank statements. You can even do affidavits and letters from employers, friends, neighbors. There's a lot of various documents that immigration attorneys such as ourselves are really good at advising people on how to fill the requirement of proving documentation, where most people don't try to collect documentation for 10 years because of their illegal presence in the United States. You also need to, of course, be able to prove that you were married to your qualifying U.S. citizen relative before June 17th, 2024. So you should probably have your marriage certificate ready to go. Either that involves the marriage certificate from here in the United States or a marriage certificate for a marriage that took place outside of the United States with a certified English translation. You also should probably just have general identity documents with certified English translations, such as if you have a passport. If you don't have a passport, you should have some other form of valid government issued ID. So you can start the process of getting one of those if you don't already have one. You also, of course, need your birth certificate with a certified English translation, as well as other identifying documents.
Of course. And those are all really helpful tips, Allison. Thank you. And of course, proof that your spouse is a U.S. citizen, right? So their passport or naturalization certificate or their birth certificate from here in the U.S. What about kids? How can parents help their kids to prepare for this process?
Well, I suppose the best way to help your kid prepare for the process is to collect the same or similar documents to what you as the parent are collecting for these items. So again, you have to have the qualifying document showing that there is a valid marriage between the parent and the U.S. citizen. You also have to have identifying documents such as a passport, a government issued ID of some sort to prove that you are who you say you are, as well as, of course, a birth certificate. Specifically, the birth certificate is extremely important when it comes to the context of the U.S. citizen parent and the qualifying parole in place parent having been married. If they're married and if you are their biological child, of course, you'll need your birth certificate to prove so. And if you are a stepchild, you're going to have your birth certificate showing that you are the biological child of the qualifying parole in place parent. Another important aspect of documents that you can start collecting, but we don't exactly know how they will be needed in the future, are documents to show that you're a person of good moral character. So this includes certain documents like proof that you've been employed, proof that you're paying your taxes, even if it's through a taxpayer identification number because you don't have a social security number, employer letters, letters from prior employers or neighbors saying that you're a good person and a good parent, that you're not loud, you take care of your lawn, you take care of your family, you're a reliable person. You can also do things such as church letters. So if you attend church or any other religious service, you can always get a letter from your pastor, your priest, your imam, or your other religious leader. These are all good documents that help point to good moral character by USCIS standards.
That's a great point. Thank you. Good tips. A lot of people who might be going through this process may have already filed or be in the process of filing an I-6018 provisional unlawful presence waiver. And we know these have been taking years to be approved. So what would you say to those people? Should they still go for the parole in place?
I always say the more the merrier when it comes to an immigration context, as long as they're not competing applications. So we know that a parole in place application in this new context is not a competing application with an already existing or a future existing 601 or 601A provisional waiver application. What that means is you can have both done simultaneously. If you've already filed your 601A and it is not frivolous, of course, then you can remain pending in that. And you can also file your parole in place. And we're of the mindset that it's whichever comes first. So whatever is approved first, whatever status you're able to get first, that's the status you go forward on. And we can always withdraw the prior submitted application or a later submitted application as needed.
Thank you so much, Allison. Those are great tips. Thank you so much. I guess the other thing to add is that even though we have done so many provisional and lawful presence waivers, of course, there are people that are nervous about the prospect of having to travel back home to pick up their visa. So if the parole in place comes first, even if you have an approved I-601A, you might choose at that point to just go with parole in place. Besides that, Allison, any other advice you would offer to people thinking about applying for parole in place?
Yes, my number one piece of advice: work with a qualified licensed immigration attorney. And that doesn't include just any attorney. It has to be somebody who focuses on immigration, because immigration attorneys don't do other kinds of law for the most part, just like other kinds of law don't do immigration. So it's good to always work with a qualified immigration attorney. And in addition to that, don't get scammed. With any new process that happens in immigration, there are all sorts of new scams that pop up. Don't answer calls. Don't give your information to some random person who calls you on the phone saying that they think you qualify for this and asking for your personal information. Don't start applying for things with anybody who just agrees with you, who says that they can get you status quickly. You need to wait your turn. You need to wait until August 19th, 2024 to submit your application. And you also need to work with a qualified immigration attorney. So that is my number one piece of advice to everyone looking into this new program.
Excellent advice, Allison. It's really unfortunate that when it comes to immigration, and especially something new, all the vultures come out to take advantage of people. So really important to know that you can trust the person you're working with. And we're, of course, here to help anybody that has questions about this. If you want to discuss parole in place or any other immigration matter, give us a call at 833-848-7838 or check us out online at www.hemrick.law.